Person at the jail, what is your name?
Mackenzie Carpenter.
This is case number 253920 FY, the people of the state of Michigan versus Mackenzie Troy Carpenter. We're here for an arraignment. Mr. Carpenter, is East Falmouth Road a good mailing address for you?
Yes.
Did you have the opportunity to meet with somebody from the defender's office today?
I did.
I have a complaint that alleges that on or about September 1st, 2025 in Herring Township of Wexford County, it is alleged that you committed the offense of malicious destruction of fire or police property. That is a felony punishable by up to 4 years in prison and or a fine of $5,000. In count number 2, it is alleged that you committed the offense of police officer assaulting, resisting, and obstructing. That is a felony punishable by up to 2 years in prison and or a fine of $2,000 with consecutive sentencing if it happened in the place of confinement. In count number 3, it is alleged that you were a disorderly person drunk at Meijer. That is a 90-day misdemeanor and or a fine of $500. Do you understand those charges and the potential penalties?
I do, Your Honor.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to. And you have the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Do you understand that?
I do, Your Honor.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I intend to hire a private attorney.
All right. The court will mark that you plan to hire your own attorney, will enter a not guilty plea on your behalf, and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that these crimes had occurred, and 2, probable cause that you were the person who committed the offense. If the prosecution is not able to do that, the case would be dismissed. If they are able to do that, you'd be ordered to stand trial in circuit court. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, in 20, I show an operating while visibly impaired. In 21, an open intox. In 17, there was a 7411 case. And then just this past Thursday, there was a plea to a disorderly drunk. Any comment regarding bond from the defender's office?
Yes, Your Honor. Obviously, defendant has a history of similar offenses, but I would note that he lives in the area, or relatively in the area. He is employed at the Mosquito Authority. He's been employed for 2 years. He lives at his family home, so he's got family in the area. I don't believe he would be a flight risk. I cannot say this for certain, but you didn't mention at least any FTAs or anything from the previous case. So assuming that I'm not making that up, I would think that's a good sign that he plans to come to court. I believe his mother is in the audience. Yes. So I would ask for a personal recognizance on alcohol testing and drug testing as the court says fit. Thank you.
Thank you, Mr. Carnes.
Thank you, Your Honor. This is concerning. I do recall the defendant being here on Thursday for very similar. In the court remarked you could have been charged with R&O in that file. So seems to be escalating. Voluntary 231.
231.
Yep. And in this instance, he was struggling with Trooper Campbell, and then later on, appeared to have kicked Deputy Walensky and was also struggling with Deputy Fisher. So we do have actual assault and battery on police officers here. Given the escalating behavior, I think the $25,000 bond is appropriate, and I think daily alcohol testing is appropriate as well. Thank you.
Counsel, I'll put on the record just so it's out there. I don't believe it causes a conflict, but I happened to be at the Meijer store yesterday. I didn't see anything happening other than 2 state police cars out front. I don't even know if it was related to this. It would have been around 5:30, 6 o'clock that I was there yesterday evening. So,
For the record, I was there too. I did see him in the police car kicking the windshield.
okay, so
Meijer or Walmart, I'm sorry.
Meijer.
Meijer.
I did not see Ms. Carey there, if anybody's wondering, but, okay, so I don't believe that creates a conflict for me. We'll leave that up to the prosecutor's offices, whether or not it creates a conflict from them, but I just wanted to put this on the record. It does appear that Mr. Carpenter is a threat to the community. He was here on Thursday for a plea and sentence, if I recall, to a disorderly drunk. I do recall that during that time period that he was on bond, we did not have any bond violations with him. But clearly, essentially, the first chance he gets to a .231 and is alleged to be fighting with law enforcement and kicking out the windshield of a patrol vehicle. I do find him a threat to the community. Bond will be set at $25,000 cash or surety, with the following conditions: that he appear as ordered, keeps contact information current, not leave the state without permission, and to commit no new crimes, that he not consume any alcohol, that he be placed on daily testing. If he does bond out, he is to be on a GPS tether for location purposes. I'm sorry, house arrest, terms set by community corrections. Thank you, Jail.
All right, let's talk about that. This arraignment in front of Judge Corey J. Wiggins had a little bit of everything. Serious felony charges, a defendant with a history of alcohol-related run-ins, a bond debate that got tense, and even the judge himself disclosing he'd happened to be at the very store where part of the alleged incident occurred. It was steady, professional, and just unusual enough to be memorable. Mackenzie Troy Carpenter faced 3 charges: malicious destruction of police property, resisting and obstructing officers, and being disorderly and drunk at a Meijer store. Carpenter's demeanor was subdued but cooperative. He answered clearly, stated he planned to hire his own attorney, and gave short, respectful "yes, Your Honor" responses. But the context was rough. He'd just been in court the previous Thursday for a disorderly intoxication case, pled out, and now, almost immediately, was back again with more serious allegations. His body language and tone suggested someone resigned to the process, but not particularly combative. The at-hangs professional. The public defender's office noted Carpenter's ties to the area: living at home, steady employment at a mosquito control company for 2 years, and family support. They argued for a personal bond with alcohol and drug testing, highlighting that he hadn't missed court appearances in past cases. The prosecutor, on the other hand, came in firm. She pointed out the escalating pattern. Thursday's plea was nearly charged as resisting and obstructing, and now there were actual physical struggles with officers and even allegations of him kicking out a patrol car windshield. Her delivery was calm but decisive, and she pressed for a $25,000 cash bond with daily alcohol testing. It was a sharp contrast, one side leaning on stability, the other on public safety concerns. Judge Wiggins handled as characteristic balance of patience and firmness. He methodically explained the charges, rights, and process to Carpenter, then shifted to bond. The most striking moment came when Wiggins disclosed that he'd been at the Meijer store around the time of the incident. He hadn't seen anything other than patrol cars, and he made clear he didn't believe it created a conflict, but he still put it on the record. That level of transparency was notable, and it underscored his careful, fair-minded approach. From there, he cut to the heart of it: Carpenter's quick return to court after a fresh plea, his .231 alcohol level, and the violent allegations made him a danger to the community. Bond was set at $25,000 cash or surety, with GPS tether, house arrest conditions, no alcohol, and daily testing if he bonded out. The overall courtroom atmosphere weighty. No chaos, no raised voices, just the steady gravity of a defendant facing a clear escalation in conduct. The attorneys were professional, the defendant was cooperative, and Judge Wiggins kept the proceedings orderly while making sure the public record was crystal clear. It wasn't flashy, but it was a good look at how district court handles repeat appearances, bond debates, and the balance between fairness and public safety. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.